Thank you. Dakota? Welcome to State Affairs.
Thank you, Mr. Chairman, and thank you, Representative Boyle, for presenting this bill and working with us in advocating for this important legislation. Members of the committee, House Bill 243 is a very important piece of legislation. It attempts to clarify numerous ambiguities that currently exist in the concealed carry licensing provisions of the code, specifically 183302 and 183302K. You know you have a serious problem with the code when law enforcement, citizens, judges, prosecutors disagree on certain provisions of the code. I think as a testament to what we are seeking to accomplish in 243, people for the first time are actually reading 183302 and trying to make sense of what it says. As I said, I'm here today on behalf of the National Rifle Association Institute of Legislative Action to testify in support of House Bill 243. Today, we'll probably listen to numerous people who testify against House Bill 243. Those people are pro-gun people. Many of those people are our membership. Even with that testimony, I'll tell you that I'm as proud of this legislation as I've ever been of any legislation on behalf of which I've advocated. The reason I have so much pride in this legislation isn't because this is a sexy bill. It's not. It doesn't have a memorable name or catchy name like constitutional carry or campus carry. It isn't because it will increase our membership. There are many in our membership who are upset about this bill. It isn't because it's going to give me personal notoriety, and this testimony is. The reason that this bill is so important is because it's necessary. It's absolutely necessary. You know, people in legislature oftentimes say that making laws is like making sausage. I would say drafting this bill is a lot like cleaning your attic. And I say that because it's laborious, it takes a long time, it's hot up there, this one proverbially speaking, and few people will ever notice it and understand everything that went into it. But every once in a while, when you're up there and you're going through things that have previously been relegated to the attic, you find something, an heirloom perhaps, something that catches your eye and deserves to be put in the house and to be noticed. And that's what we accomplished with House Bill 243. We found some rights that have been hidden in the code that people didn't understand, and we put them out in the forefront. We put them in list format so that people could understand them, that it didn't take counsel of an attorney to understand what your concealed carry rights are. You know, as Representative Boyle stated earlier, this is not meant to be an alternative to permitless carry. This is not intended to be permitless carry light. This is the acknowledgement of a serious problem, a deficiency in Idaho code, in an attempt to fix that deficiency. As Representative Boyle pointed out, there are numerous provisions within this legislation that are not only new, but reorganized in a manner in which people may understand it. As she rightfully pointed out, the first provision of the code applies strict scrutiny to all the provisions within this. For those of you who may not be familiar with what strict scrutiny entails, it means that every interpretation of this code now has to be every attempt to usurp provisions of this code has to be narrowly tailored to accomplish a compelling government interest. That wasn't previously in the code. We are extending the rights given to the people by Article 1, Section 11 to the maximum extent allowed by the Idaho Constitution. You know, another thing that we're doing is we're providing definitions for commonly used diction within the code. And most people might not understand the importance of this until you get in trouble. But without a definition of firearm in the concealed carry licensing code, how do you know what applies and what doesn't? It might surprise you that there actually is a definition of firearm within the Idaho code. It defines firearm in such a broad manner that includes anything that fires a projectile by gas or mechanical means. The Idaho Fish and Game has actually interpreted this to include crossbows, compound bows, and even some air guns. We needed to fix that. You know, the definition for deadly weapon, if you go to, as a matter of fact, if y'all have a bill in front of you, there's a definition for deadly and dangerous weapon. And it says, means any device, instrument, material, or substance that is used for or is readily capable of causing death or serious bodily injury. Do you know what that encompasses? Baseball bats, hammers, screwdrivers, things that weren't intended by the individual to be deadly weapons. But the way that the language is currently drafted is so broad that it encompasses that. What we did is narrow that down. You know, the term concealed weapon. You always hear that Idaho is an open carry state, right? A constitutional open carry state. Well, open carry is not defined anywhere in the Constitution, neither is concealed weapon. Now you have a definition for what is openly, what it means to open carry and what it means to concealed carry. You know, loaded. There are provisions right now in the code that reference unloaded firearms, but we have no definition for loaded. Does it mean one in the chamber, one in the magazine? Does it mean close proximity of ammunition in the firearm itself? We provide that definition in here. Another thing that we do is we go throughout the code, and we combine sections that weren't previously combined and put them in list format. If anybody has had the unfortunate opportunity to read the current 3302, it's a mess. You'll have paragraphs, sectional paragraphs that extend for 3 pages. You don't know where anything is and where it can be found. This bill fixes that. If 243, House Bill 243 were to pass, a common layperson can open their code, understand what their rights are under current law, what the restrictions are under current law with regard to concealed carry, and if they want to go avail themselves of the right to get a CWL, they'll know exactly the chronological process by which they have to go, starting when they go to the sheriff's office and apply for an application or receive an application, all the way to what their license is going to look like, the stuff that's required on their application, and everything that entails. I would like to close by saying, and I believe that I will be able to reserve some extra time to answer any questions after other people have testified. But when I said this, I'm as proud as this bill of any other bill I've ever advocated before, and I've advocated on some well-known bills, even in front of these people right here. Some bills that were written about. I mean that. And I mean that because this isn't something that is going to bring praise upon anybody, but it's something that's necessary. It needs to happen. The citizens of Idaho deserve a clear code, a clear and succinct code. And this is what I'm attempting, what I wish to accomplish with House Bill 243. Thank you, Mrs. Vice Chairman, and I will stand for any questions.
Thank you, Dakota. Committee members, do we have questions for Mr. Moore? Representative Barbieri.
Thank you, Madam Chair. Sir, how many different firearms proponent organizations are there in the nation? Do you know? You have a round ballpark figure?
Mr. Moore.
Mrs. Vice Chair, you know, there are a lot of national firearms organizations. I believe the National Rifle Association is the largest and oldest of those organizations, but I am familiar with other national organizations as well, as most states do have state organizations and organizations within the state that represent the interest of gun owners in the state.
Madam Chair, follow up.
Chairman Barbieri.
Thank you. I'm just, Dakota, I'm just fascinated by the singling out of the National Rifle Association as one of the organizations from which one can gain a certificate. Is there some reason that NRA is singled out here 4 or 5 times in the code itself as opposed to any nationally recognized firearms proponent organization?
Mr. Moore.
Madam Vice Chair. Representative Barbieri, well, first of all of this language referencing the National Rifle Association is existing in code. It isn't new as a result of 243. There's not a single additional reference to the National Rifle Association that wasn't currently existing. Now, I would like to answer your question as to why I believe it's in there, and the reason I know that's in there is because You go to school, Mr. Barbieri, and you hang a diploma on your wall. Is that diploma going to mean something? Is from an accredited school or an unaccredited school? The reason I say that is because the National Rifle Association, being the longest pro-gun organization and having the most extensive setup with regard to training requirements, we actually wrote the book on the training. And the reason that the National Rifle Association is referenced is because we keep constant accreditation standards by which all the trainers who teach the course have to abide. We annually revoke licenses for training all around the country, and that oversight is necessary to ensure that individuals are actually learning the things that they are purporting to know based on holding themselves out to have appropriate training. So that's why I believe it is referenced in the code, but I would like to say that none of those references are introduced through House Bill 243. They're existing in code.
One more follow-up, if I might.
Follow-up, Representative Barbieri.
Thank you. Well, just with respect to this one issue, is there language in here allowing for someone to get a certificate from, other than police and government organizations, is there language in here allowing someone to get a certificate from any other private gun proponent organizations?
Mr. Moore.
Madam Vice Chair. Representative Barbieri, yes there is. So I will direct your attention completion of any firearms training or safety course or class. It is page 4, line 14. Completion of any firearms safe training or safety course or class conducted by a state certified or National Rifle Association certified firearms instructor. So if you're certified by a state organization that's recognized by the state of Idaho, then yes, you will be able to do it. I'll also direct your attention to, and it is in 3302K, and it would be page 10. And let's start with line 3 and go through line 7. The sheriff must accept as a qualifying handgun course, a personal protection course offered by the National Rifle Association or an equivalent, provided that all personal protection or equivalent courses meet the following requirements. So yes, it does afford anybody the opportunity to submit training that is equivalent to what the National Rifle Association provides, or any other training that the state has deemed worthy of certifying for firearm instruction purposes.
Representative Barbieri, are you finished with your questions?
For right now, Madam Chair, thank you.
Thank you. Representative Wintrow.
Thank you, Madam Vice Chair. Or Chair, I guess you're the chair today. That's right. Dakota, oh, I forget your last name.
It's, Madam Vice Chair, it's Moore.
Okay, Mr. Moore. Thank
Yes,
you.
ma'am.
Madam Chair, I have a few questions if that's okay.
Okay.
Thank you.
Just a reminder to the committee, we're on the floor at 10 o'clock this morning, so if we can keep that in mind. Representative Wintrow.
Okay. On page 1, 183202, concealed weapons, the first thing says the legislature hereby finds that the people of Idaho have reserved for themselves the right. The second sentence, as you noted, the provisions of this chapter regulating the carry of weapons must be strictly construed. Talk to me about why that sentence is necessary.
Mr. Moore.
I guess, Madam Chairwoman, that sentence is necessary because we want to ensure that the maximum extent of the rights that the people have reserved for themselves are held in this statute. So any of these provisions in this statute become subject to statutory interpretation. A judge takes a look and is trying to analyze a provision to see the extent that it goes or whether someone is committing a crime. If there is ambiguity within that, or the legislature in the future tries to create another statute that might curb the rights that are granted, say an open carry provision, which Idaho Code does not currently, it seems, allow for the legislative enforcement of or regulation of, then the judge would have to look at and they'd have to see if there is a compelling government interest and if it's narrowly tailored to achieving that interest.
Madam Chair, follow-up.
Follow up?
So Dakota, I think what you're saying is that typically a judge or a police officer or law enforcement agent, when they come across an individual incident, will need to make some determinations based on the complexity of that one situation. Is that correct?
That's... Sorry. Mr. Chairman?
Go ahead.
That is correct. There are always circumstances in which the code needs to be interpreted by law enforcement. That's the nature of our laws. If that wasn't the case, then I wouldn't have had to go to school for 3 years to become an attorney. That being said, yes, there are instances in which either the legislature enacts legislation or the judge is forced to interpret legislation, and there are standards by which standards of scrutiny by which judges use to interpret the efficacy or the constitutionality of those legislations. We are applying the strictest standard because we believe that it is an inherent right, the possession of firearms, and that should be stated in the code.
Mr. Chair, follow-up. Thank you, Mr. Chair. Dakota. So let me give you an example and ask you to weigh in on it. So I did ask a number of attorneys and law enforcement folks about that sentence. That stuck out to me the first thing I read the bill. And everyone I spoke to said, I don't know why that's in there. It's as if you decide you're going to have an accident. So if I'm a driver and I decide every time I'm going to get in an accident, I'm going to veer to the right instead of the left. I'm always going to go to the right, never the left. Wouldn't that not necessarily be a good decision? And it seems like that's what the statement is saying, is no matter what, we're always going to go a certain way instead of allow room for interpretation with a law enforcement agent or a judge. So I'm wondering, how does this statement help a law enforcement agent know how to do his or her job better?
Mr. Moore?
Mr. Chairman, it doesn't. What this is provided for is to give guidance to judges in making determinations on legality. I'll give you an example. A few years back, there was a case called the Treble case. And what it had to do was, or what it dealt with, was preemption statute and whether the University of Idaho could prohibit an individual from possessing a firearm on campus under the preemption statute. And if you pull out that opinion and you look at it, you'll see that I think the first 3 or 4 pages deal with the standard scrutiny by which the judge was going to use to interpret the provisions of that Constitution. So whether they were going to use rational basis review, intermediate scrutiny, or strict scrutiny. It took them 3 or 4 pages to get to that point. We're directing them through the legislature that anything that deals with interpretation of these issues, strict scrutiny is applied. I hope that answers your question.
Mr. Chair, follow-up.
Representative Winthrop.
Thank you, Mr. Chair. Dakota. So what you're saying is if a law enforcement agent comes across somebody with a weapon, you're always going to side with the individual with the weapon versus the law enforcement agent and their discretion.
Mr. Moore?
Mr. Chairman, that is absolutely not correct. We're talking about appellate review on this. So it's difficult without facts before you giving me a fact pattern, a procedural history of a case, to come in and to say how this will be interpreted. This is merely a manner of appellate review and I guess the regulation of conduct that is granted, the rights that are granted within the Idaho Code.
Mr. Chair, another follow-up on that line, this one.
Representative Winthrop.
So Dakota, is it common practice in our Idaho codes and otherwise that we would write into law how the judge would have to interpret a law?
Mr. Chairman, I'm not familiar with other provisions of Idaho Code that do it. But I know that I am familiar with the Idaho firearms law, and I believe that many people in this state would agree that they should be afforded the maximum rights as provided in the Idaho Constitution.
Mr. Chair, follow-up.
Representative Winthrop.
Thank you, Mr. Chair. Dakota. So I do want to go down another line of questioning, and then I'll turn it over to someone else. But the other big difference in this piece is currently the code says if you're outside of city limits and you're engaged in a lawful outside or activity like hunting, trapping, or fishing, you can carry concealed without a permit. This this takes that out and just says outside city limits. So what you're saying in this new bill is that if you're inside city limits, you still have to have a concealed carry permit, but outside city limits, you do not. And does that also include any car with the gun loaded?
Mr. Chairman? Thank you, Representative Winthrop, and I'm glad you brought up this provision. So under current law, if you go to subsection 9 of existing, so 183302, or 183302 subsection 9, it currently has a provision, and I'd be more than happy to read it to you if the chairman would indulge me just momentarily. So 183302, subsection 9 says, while in any motor vehicle inside the limits or confines of any city, a person shall not carry a concealed weapon on or about his person without a license to carry a concealed weapon. So current law, the provisions that apply to carrying of concealed weapons, loaded concealed weapons, only apply inside city limits, inside your vehicle. Now you did correctly reference 183302 12, or 183302 13, and it is, or no, it is 12. 183302 12D. And 12D does say, the requirement to secure a license to carry a concealed weapon under this section shall not apply to the following persons. And then it goes down to D to say any person outside the limits or confines of any city while engaged in lawful hunting, fishing, trapping, or other lawful outdoor activity. So it does say lawful outdoor activity. The problem with that language is, what does lawful mean? I believe that if I'm walking down the street, breathing, I'm engaged in a lawful outdoor activity. If I'm bird watching, I'm engaged in a lawful outdoor activity. And so we need to clear up that ambiguity. As a matter of fact, last year, House Bill 514 attempted to do that. And I believe it passed the legislature with only 7, or it passed the House of Representatives with only 7 dissenting votes. So members from your caucus did agree that this needs to be clarified.
Mr. Chair, follow up.
Mr. Winthrop.
So Dakota, I guess what I'm asking is, does that now mean if I'm outside of city limits, I do not need a concealed carry permit at all, and I can have a loaded gun in my car on the road outside city limits?
Mr. Chairman, that is correct.
Mr. Chair, follow up.
Hasn't that always been the way it's been?
With regard, Mr. Chairman, with regard to the vehicle, that absolutely is correct. That's the way it's been since 1990.
Representative Winthrop.
Chair, follow up. I talked to one sheriff at least, I'll say, and I don't think that was always the case, clear, but regardless. So my last question, so why the difference? Why do I need to have a concealed permit in city limits versus outside of city limits? What's the big difference there?
Mr. Chairman, well, first of all, I'd like to acknowledge the first thing that you said, which is there are sheriffs that disagree on this, right? I believe that 183302 subsection 9 is very clear with regard to possession of a loaded firearm in a motor vehicle outside city limits. But the fact that there are sheriffs, there are law enforcement that disagree on this and probably enforcing it based on their belief is a clear display of the necessity for this bill, because it makes it very clear. Second of all, what I would say with regard to why the distinction between outside the city limits and inside the city limits. If you're inside a city, you are, and I must say that I unequivocally believe that there is no inherent distinction, because I believe that these rights should extend to everyone, whether inside the city limits or outside the city limits, but that's not the bill we're testifying on. The one thing that I will say is that, say, take Idaho County for instance. I think it probably spans 200 miles. You might be 70, 80 miles from the nearest sheriff at any given moment. That situation never arises within a city with regard to police departments. You'll always have somebody, whether it's prompt enough or not, which usually it isn't, but you'll have somebody there, a law enforcement officer there, generally upon a call. That doesn't always happen in counties. That doesn't always happen in rural counties, and so that's the big distinction here. That's originally why this provision was put in. And I believe that it needs to be clarified and remain in there.
Mr. Chair, follow up.
Representative Winthrop.
Dakota, the question is, why do I need to have a concealed carry permit in the city and not outside the city limits? Because the confusion part to me is, there's two questions there for me actually. When I'm driving from Boise to McCall, I'm going to pass in and out of city limits and outside about 10 times. So at some point, I'm going to be legal, illegal, potentially. From here to Caldwell, it's like 7. So, but more importantly, why do I have to have a concealed carry permit in the city and not outside? What is it? Safety? Is it I'm looking out for people, background check? What is it?
Mr. Chairman, so that's a very good question. And if you would like to extend, if you'd like to carry a bill that extends concealed carry inside city limits as well as outside, I'd be more than happy to support you on that.
I guess I'm not going to get my question answered today, Mr. Chair, so I'll turn my light off and let somebody else ask.
For a change, I don't have a historical perspective on that. Representative Luker.
Thank you, Mr. Chairman. Dakota, you mentioned in your opening that this also clarified open carry. I don't see a definition of that. Are you just using the concealed weapon definition as the opposite?
Mr. Chairman, yes, Representative Luker, and what I'm saying is that it's because you have a definition for concealed weapon, you inherently have an inverse definition for openly carried weapon. But that, I mean, concealed weapon means any deadly weapon carried on or about the person in a manner not discernible by ordinary observation. And so if it would, I guess, stand to reason that if you remove that not, then that would be open carry.
Representative Luker.
Yeah, different question. Dakota, on page 2, the definition of loaded, line 11, it talks about any internal magazine of the firearm. Is the magazine of a revolver, would that be internal?
Mr. Chairman? Yes, Representative Luker, that would be internal. And another thing that this specific provision would also apply to is, say, your Remington 700, it's a rifle, and it doesn't have a detachable magazine like most, or like a large number of bolt-action rifles do. You actually insert it through, insert the ammunition through the chamber itself, and so that would what this is attempting to legislate. So with regard to both revolvers and this type of device.
Mr. Chairman.
Representative Luker.
And Dakota, I guess I see a little bit of ambiguity there. Is there a reason you used internal as opposed to some other word that would make it clear that it's part of the weapon? Because I could see at least a semantic argument on a revolver, whether the magazine on a revolver is internal or external.
Well, Mr. Chairman, so if that was the ambiguity on there, and I would say that most revolvers that I'm aware of do have a detachable, the magazine would be detachable, and so then in that case it would fall under 3, and so in either situation you would still have a clear definition for what it was, whether you use Roman numeral 1-2 or Roman numeral 1-3.
And
Representative Luker.
yes, thank you. One other question. Dakota, is there any provision in here about allowing a city, let's say a small rural city, to waive its the requirement that the permit be required in the city?
Mr. Chairman, no, that is something that was discussed, but it would be in contravention of Idaho's preemption statute, and as hard as work that was to get passed, I didn't want to do anything to possibly place those provisions in jeopardy. But it does bring up a good point that this bill will allow now, it will recognize private property owners' authority to dictate conduct on their own private property, and so a private property owner in city limits would be able to give explicit permission to allow the carrying of concealed weapons on their private property.
Representative Cheatham.
Mr. Chairman, Dakota, just for kind of a point of clarification, revolvers refer to cylinders and semi-automatics refer to detachable or removable magazines. I just following up on, just for a point of clarification.
Mr. Chairman? Thank you, Mr. Cheatham. Or Representative Cheatham, I apologize for that. I'm not trying to demote you at this time.
Representative Nielsen.
Thank you, Mr. Chairman. Sir, a moment ago you said that private property owner within the city could get permission or some type of activity where they could allow concealed weapons or not concealed weapons, open carry or otherwise, on their own property. Who do they have to go to get that, and is it automatic that they can have it, or do they have to qualify somehow?
So, Mr. Chairman,
Moore.
Representative Nielsen, so I would direct your attention to page 2, line 22 and 23, and it says, and I will start with the prefatory clause, no person shall carry concealed weapons on or about his person without a license to carry concealed weapons except on private property where the person has permission to carry concealed weapons from any person with an ownership or leasehold interest in the property. So the person who lawfully controls that property at the time. So say someone, do you live in, and I apologize, Mr. Chairman, do you mind if I ask Mr. Nielsen a question for purposes of this exchange? Do you live in a city?
No.
Okay. Well, say you did live in a city. It would be illegal for you to say, if your son came over, to say, yes, you can have a concealed weapon on my property. I don't believe that that is right. I believe that a private property owner is in the best position to dictate conduct that takes place on their private property, as they are the ones who would be incurring the potential liability on that. So if you wanted to give permission to be able to regulate conduct on your property, you now could.
Further questions? Representative Barbieri.
Thank you, Mr. Chairman. Okay, Mr. Moore, so let's start with your legal conclusion on the term equivalent on page 10.
All right.
What is an equivalent? Line 6.
Mr. Chairman, I think I guess the answer to this question really answers your initial question. Can you name another firearm certification safety course in the United States that offers equivalent background and certification process as the National Rifle Association course? I don't know of any, so I can't answer that question. But I can say that if there is a standardized course that has reasonable oversight and accreditation standards that the National Rifle Association course does have, and they meet all of the standards by which this training is based on, then I guess that equivalency would, in effect, be taken without having to undergo the National Rifle Association course.
Follow up, Mr. Chairman.
Representative Barbieri.
Thank you. Mr. Moore, page 9, 34 and 35, basically goes the negative of what we talked about earlier, which I'll get back to in the earlier sections. This says, or does not meet all of the following qualifications, and then we switch over to the equivalent. Why don't we have the same requirement on page 3 that a sheriff must accept any one of the following, and have the equivalent language in here as well?
Mr. Chairman, it's because, and I was, if you remember, Mr. Chairman, Representative Barbieri, if you recall, I believe this legislation was passed in 2012 by the Idaho legislature, 183302K. That predated my time working in this legislature. I do know that it passed by substantial margins, and that it has been successful in its primary goal, which is to extend reciprocal agreements with other states for individuals who wish to not only achieve training and competency that they might felt that they personally were otherwise lacking, but also to extend the ability to travel into other states. I'm not familiar with why it was written in the negative, but I would assume that if properly vetted during the committee hearing process, there was a pretty good reason for it.
Follow up, Mr. Chairman.
Representative Barbieri.
So, Mr. Moore, then what I'm understanding is that if we had put the equivalent language in the must language, the problem with reciprocity would have been raised its ugly head.
Mr. Moore.
Mr. Chairman, I can't answer that, Representative Barbieri. I apologize. I was not here during the passage of this this legislation. I have no idea what the intent behind that specific issue is.
Follow up, Mr. Chairman.
Senator Barbieri.
So, Mr. Moore, you didn't make any attempt to modify this section we're talking about here on page 3. You just kind of cut and pasted that from the original language.
Mr. Chairman, we did make changes, but none of the changes were substantive. They were all ordering, such as we saw in 3302. The reason that I was hesitant to go into 3302K to make any substantial changes is that many of you might recall that in July of 2014, Washington finally recognized reciprocity with the Idaho Enhanced License, which I know is substantial for many people who live in northern Idaho, who oftentimes travel into Washington. And so there was no attempt made by me to do anything that might harm that reciprocal recognition.
Thank you. A different line of questioning, Mr. Chairman, but I think it just should be probably just be one question long.
Say a long question.
Yeah, just one more question on top of that, unless he makes another response. Thank you. Page 8, lines 14, 15 in here. So this is all existing language as well, right? This intending to communicate serious expression. This is all in the present code.
Mr. Chairman?
More?
Yes, Representative Barbieri, that is all existing language. The only provision that was changed in there is that we removed the definition of firearm because of in the prefatory language of 133302(1), we say that for purposes of this chapter, these are the definitions. And basically what that means is unless otherwise defined, the definition of firearm that's in 133302 or 183302 is now going to be used in any instance in which the term is used, and so there's no necessity to redefine it.
Follow up, Mr. Chair.
Senator Barbieri.
Thank you. So, can you give me the National Rifle Association's official perspective on this First Amendment issue here on line 15, that they intend to communicate and that that the prosecution does not need to prove actual intent to carry out what they've stated?
Mr. Chairman, I can't give you any National Rifle Association official position on this. You might be correct that it goes into a First Amendment issue. I would disagree from a legal perspective because there are intent to induce fear definitions with regard to aggravated assaults, and we see that in nearly every code in every state. Now, with regard to the explicit provision with regard to the element of the crime that is not necessary to prove the defendant actually intended to carry out the threat, that's not currently, I believe, standard by which aggravated assault is prosecuted. I think that the mere conveyance or the inducement of an apprehension of fear is enough to be aggravated assault. So I believe that's probably where they're getting this language.
So Wintrow.
Thank you, Mr. Chair. Dakota, my last kind of set of questions is really kind of, I guess, obvious. I can't believe I didn't ask it first, but somebody like me, the permitting process seems to be just like a normal part of safety and checking and making sure things are done right and the person that has a gun should. Right? What is so burdensome about having folks carrying a concealed, who want to hide a gun in their coat? What is so burdensome about having to get a permit and go through the training?
Mr. Chairman, Representative Wintrow, I would like to maybe further ask you what this line of questioning is intended to go out. We're talking about House Bill 243 right here. I don't know if so that's what you're referencing?
Mr. Chair.
Mr. Wintrow.
Thank you, Mr. Chair. Dakota, so again, if I have to get a concealed carry permit inside city limits but not outside, again, I don't understand what makes it more safe. For me, I see permitting as a safety issue. Maybe you don't. Maybe the NRA does not see or care for permitting process at all. But for me, it's about safety, and I'm just not sure, like, when I step 2 feet outside of city limits, what's different for me or anybody else if I want to hide a gun.
Mr. Chairman, I think that might have been a question that would have been more appropriate in 1990 when sections 183302 subsection 9 and 183302 12D were passed, and they made that policy analysis that there was a distinction between outside the city limits and inside the city limits.
Representative Wintrow.
Mr. Chair, Dakota. Does the NRA oppose permitting?
Mr. Chairman?
Mr. Moore.
The National Rifle Association in many states and including really everywhere that I work would be proponents of a well thought out and well written provision that allow permitless carry throughout the entire state of Idaho. We believe that is a fundamental right of all law-abiding gun owners to be able to exercise their right. The problem in the state of Idaho is that in 1978, the people voted to give the legislature authority to regulate the carrying of weapons concealed through Article 1, Section 11 of the Idaho Constitution. So from that perspective, I believe that it is a policy debate that you can gear up for, because I anticipate it will probably be coming more in the future, but one that is really not addressed by this legislation, because this merely seeks to clarify existing law.
Mr. Chair, follow-up?
Representative Wintrow.
Thank you, Mr. Chair. So on page 1, you're writing in that the legislature shall have the authority to regulate the carrying of concealed weapons.
Mr. Chairman, I'm not writing that in. That's actually straight from the Idaho Constitution, Article 1, Section 11. I'm merely repeating that and saying to the maximum extent that the people retain rights under that constitutional amendment, they will be able to be granted those rights.
Thank you, Mr. Chair. And Dakota, so again, you're acknowledging the legislature does have the right to, the government regulates a lot of things for the safety of their citizens. And I guess I just don't understand why getting a permit inside or outside if you're going to hide a gun is such a bad thing, and how it's, you know, such a bad, burdensome thing.
Mr. Chairman, that is, so you're absolutely correct that it does explicitly say that in the Idaho Constitution the legislature can regulate the carrying of weapons concealed. So it is no longer a constitutional argument. It's a policy argument on whether the legislature wants to give that right back to the people, which the National Rifle Association believes that they probably should have. However, I will answer your question the same as I have on multiple other instances. This provision does not seek to change anything with regard to carrying outside of city limits. I agree that that might, I guess, encompass an arbitrary line that safety is, you know, whether it makes it more safe or less safe, I'm not here to state. What I can state is I wanted to remove ambiguity that exists in current law, because as you yourself stated, your sheriff, or at least one sheriff that you spoke to, believes that 183302 subsection 9 does not permit the lawful carrying of a loaded firearm outside city limits. I would believe that everyone who reads that, and you ask any attorney on the issue, that it clearly does, but the necessity to clarify that is, I guess, embodied by the statement of your sheriff, or the sheriff who you spoke to.
Further questions? Representative Crosby.
Thank you, Mr. Chairman. Mr. Moore, I wanted to ask you about page 2, line 24, kind of still along those lines of being outside the city limits, and the old language stating 18330212D that permits carrying of concealed weapons, carrying of concealed weapons without a license outside the limits or confines of any city while engaged in lawful hunting, fishing, trapping, or other lawful outdoor activity. And that other lawful outdoor activity having the ambiguity attached to it. Line 24 doesn't seem to be a clarification, but really more of an expansion, since the old language is prefaced with lawful hunting, lawful fishing, lawful trapping. I mean, certainly there's room for argument, but doesn't line 24 really provide more of an expansion rather than true clarification?
Mr. Chairman, Representative McCroskey, you're absolutely correct. That inevitably in trying to clarify this, it does result in an expansion. Because even if you interpret lawful outdoor activity to mean anything, so let me rephrase this. I work with a lot of other states, and you go into their code, and a lot of them have nuanced things, and they provide provisions for, you know, you possession of a firearm while engaged in a lawful outdoor activity. What that usually means is I can't be breaking the law while possessing it. So I can't be stalking somebody with my firearm and it not be an offense, okay? I can't be, I guess you could take it to something as nuanced as jaywalking or something like that. That obviously wouldn't be a lawful outdoor activity if you're doing so with a firearm. But the fact that it is so broad is something that needs to be clarified. Now, in doing so, we try to make a clear standard, just outside the limits or confines of any city. That seems to be as clear as we can make it. It inevitably does expand current rights. Say I can, if I have permission from somebody, or I'm on a, I walk into a building. Say the Walmart outside the city says explicitly, I call the president of the company and I say, I want to be able to carry in your Walmart. Then, or they don't post a sign. Then that would be an example where you could go inside, but it wouldn't be an expansion of any rights. The private property owner would still retain all rights with regard to their private property. And so, inevitably we did expand it, but not in any way in which we did it in the most, I guess, conservative way that we could.
Other questions? Thank you, Mr. Moore. Greg Pruitt.
Thank you, Mr. Chairman. Members of the committee. My name is Greg Pruitt. I'm here on behalf of the Idaho Second Amendment Alliance. For those of you who don't know who we are standing here today in opposition of House Bill 243. There are several reasons for this. The crux of the argument, and I'm going to try and hurry because I know there's a lot of people here that want to speak. When you look at the statement of purpose on House Bill 243, they say that they're trying to clarify the code and move the code around and all that. And that's fine. That's not an issue. The problem is that it does far more than that. It strips rights away from people that currently have it. The current Idaho code stated that any city, county, or state official has the right to carry without a permit. And then there's another provision in there that says any publicly elected official. The mantra seems to be that they're just removing it from you guys. The 105 people, that reside here during the session, they're removing it from you guys. However, it's far more than that. Our estimates are that up to 30,000 people currently have permitless carry in the state of Idaho under the current code, because any city, county, or state official has that, plus any publicly elected official also has that provision. And so we're standing here today to say that moves us in the wrong direction. We don't have an issue with trying to redefine some things and moving the code around to make it flow better. That's fine. The problem is we are removing people's rights, and that's not the direction we need to go. Thank you, Mr. Chair.
Other questions? Representative Brandon.
Thank you, Mr. Chairman and Greg. So I understand your argument. I understand the perspective. If we were to take that portion of the legislation out, that language out, would your group stand in support of this particular piece of legislation?
No, we still, Mr. Chairman, and thank you, Representative Crane, for the question. There are some other issues. I'm saying that's the crux of our argument on why that it should. There's some other clarifications. If you look on page 1, and Mr. Moore talked about this briefly on lines 32 through 39. He talked about baseball bats and some other issues. Okay, on line 37, any other weapon, device, instrument, material, or substance that is intended by the person to be readily capable of causing death or serious bodily injury falls under the the definition of deadly weapon, which also falls under a concealed weapon. So if I carry a screwdriver intended to harm someone, and that's what I want to use for self-defense, do I now have to have a concealed weapons permit just to carry that screwdriver? Because that's what it says under the definition, and the attorneys we've talked to. So there's that. There's some. We were told today by some attorneys that it actually expands the mental health background check beyond what the federal scope already is. So there's definitely some other things, but again, I know my time's limited here, and I wanted other people to have a chance. So I addressed mostly just the taking away of permitless carry from those individuals that already have it.
Call, Mr. Chairman.
Representative Crane.
Thank you, Mr. Chairman and Mr. Pruitt. So if we address these issues, would you stand in support of the legislation, or are you in opposition to the legislation because your legislation was not heard?
No, absolutely not. If all the issues that we would like to see addressed were addressed, we would absolutely support it. And I already told you, I don't have an issue moving the code around and making it flow better. That's not something that anybody here really opposes.
Follow, Mr. Chairman.
Representative Crane.
Thank you, Mr. Chairman and Mr. Pruitt. So do you have a handout typed up for us as members of the committee to look at, this section, this line, this needs to be changed, this needs to be changed? Do you have that prepared for the committee? Could you hand that out?
We can't hand that out today. We have some provisions and amendments prepared on the qualifications as far as who can carry without a permit. We have some amendments like that ready, but on some of these other issues, we don't have them addressed yet. They talk that you can do this in layman's terms. The problem is when you look at House Bill 243, and we've had this issue, people keep contacting us saying, hey, is this in the original code or not in the original code? And we're still trying to wrap our heads around what was actually changed and what wasn't changed. And so we're still digging through that, trying to do the best we can to figure out what amendments we would propose.
Thanks.
Representative Crosty.
Thank you, Mr. Chairman. Mr. Pruitt, along the lines of some of what Representative Crane was asking, would you support a piece of legislation that brought all of the stakeholders to the table to work out a good concealed weapons piece of legislation?
Sure, we would love to sit down with anybody and talk with anybody regarding concealed weapons legislation. That just didn't seem to really happen. So we weren't invited to the table.
Representative Nielsen.
Thank you, Mr. Chairman. Mr. Pruitt, this handout given to us by the presenter of the bill, Representative Boyle. Have you do you have this?
Mr. Chairman, Representative Nielsen, no. In fact, I kind of sat back there and thought, man, that'd be nice for the public to have so we could all figure out what was going on.
Thank you, Mr. Chairman.
Representative Nielsen.
May I suggest you get a copy of this and then you can run it through your processes and even help a guy like me with your interpretation of it to come forward and possibly give us more information. Thank you.
Anything that comes before this committee is public, so it is available to you now, and now it's been presented, so maybe Mr. Moore could get some copies for everybody.
Okay, who's going to bring it home?
I guess that's going to be me, Mr. Chairman, and members of the committee. Thank you all for sitting today and listening to this testimony, and even coming back this afternoon to hear further testimony. Talk about being stuck in the middle. I never see the day where we had Idaho Second Amendment Alliance in agreement with Moms Demand Action, but there's a first time for everything.